Now, therefore, the Senate resolves, 1, that the Security Laws Amendment Act number 19 of 2014 is unconstitutional and therefore null and void.
Even before Senate Minority Leader Moses Wetangula moved the motion seeking the House to resolve that the Security Amendments Act 2014 is unconstitutional, Majority Leader Kithure Kindiki, in a well-calculated move, rose on a point of order, asking the Speaker to stop debate on the motion on grounds that the matter is already in court.
I have listened with great concern as the Minority Leader gave notice of a motion concerning a matter which is squarely, directly, and actively before a court of law.
That move sparked a heated debate in the House as members of the opposition coalition defended the motion.
More importantly, Mr. Speaker, is the question of prejudice. That has not been dealt with. And it is too late now to deal with it, because the senator making the allegation should have addressed that issue of prejudice.
Judicial officers of any repute are very unlikely to be swayed by what is said in Parliament.
Senators from the ruling Jubilee Alliance argue that the debate could prejudice the outcome of the court ruling due this Friday.
Mr. Speaker, the judge could be watching the national television as I'm talking or the minority leader is talking, and you cannot prevent him from watching the television. So he could be influenced by what he sees.
It is on all fours. Everything is the same as a replica of the declaration sought and also, Mr. Speaker, of the order sought.
Friends have already gone to the final entity or institution of law to make determination on whether it is constitutional or not. Why are they reversing back to a place where it is not its responsibility?
The opposition senators warn that the Senate risks losing and compromising its independence if it does not exercise its oversight mandate properly.
That these parliaments, being the expression of the sovereign will of the people, must be allowed to speak on anything and everything wherever it is. And therefore this freedom of speech provided to this parliament, Mr. Speaker, is absolute.
Here we are dealing with a matter which is of great public interest in this country, Mr. Speaker. This is a matter, Mr. Speaker, that we can now not say that Parliament should be gagged.
But the rivals, on the other hand, blamed court for the halted debate as the opposition alliance had gone to court.
They went to court. We would have debated this issue, but you gagged us. You denied us the opportunity to debate the same issue, and you first ran to court, then you bring us back here, and you want us now to debate. You have gagged us.
Mr. Speaker, could it be that we were called here to assist in this case, Mr. Speaker, to proceed? Could it be possible that the record of this House is being sought so that it can be used to validate a process that was rushed, Mr. Speaker?
I think this is also another opportunity, so that we do not come with our hidden agendas. When it suits us as a House, we come and say this is the right thing to do. When it does not suit us, then we say it is not the right thing to do.
The Coalition for Reforms and Democracy will now peg its hopes to stop the new laws on the ongoing case it filed at the High Court, whose ruling on Friday could have major implications on the Security Laws Amendment Act. Ken Dagor, Obadia for The Big Question.